Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the limits on searches police can do when they arrest someone. This is called a search incident to arrest, and the limits of this type of search was recently considered by the Supreme Court of Canada in a case called RV Stairs. In RV Stairs, a call was placed to 911 to report a man repeatedly hitting a woman in a car. Police arrived and the car was parked, so they knocked on the door of the home. No one answered, but fearing for the woman's safety, police entered the house. Inside, they found an injured woman and the accused. The accused, Stairs, was arrested, and after his arrest, the police conducted a visual search of the basement where he and the woman had been. They found methamphetamine in clear view, and he was charged not just with assault, but also with possession of methamphetamine for the purposes of trafficking. Was the search, which was warrantless, a lawful search? What are the limits on a search incident to arrest when they happen inside the accused's home? That was a question addressed by the Supreme Court and which we're discussing today. We're joined by two criminal law experts, Ari Goldkind and Sina Shabastari. Thank you both so much for joining us today. Sina, I'll start with you. Is there anything important that you want to add to the background of the case?
Thanks so much for having me, Christine. In terms of the background of the case, I think what's particularly important to the facts, in my view, is that when the caller contacted 911 to indicate that there was this assault taking place, there was no mention of a weapon being used, and there was no mention of any other parties other than Mr. Stairs and the victim at the time. And I think that's important in regards to what ensues thereafter.
And Ari, is there anything that you think is important to know about the background of this case?
Well, I think Sina's point is exactly right. It leads me to the part that I would finish off the answer by saying the term officer safety is one we'll talk about throughout this episode. That's a catch-all term that police officers use to justify almost everything they do when it comes to a search, particularly incident to arrest. The easiest way to explain it to non-lawyers are, as soon as an officer says officer safety, they spread that term on the idea like ketchup. And when you put ketchup on everything, you theoretically make it taste better. The court here tends to accept that ketchup is a very preferable taste because the words officer safety were used.
I mean, I think we might have different senses of taste if you want ketchup on everything. But Ari, let's step back for a second. What exactly is a search incident to arrest? Can you explain what it is and how a search like that can be conducted without a warrant? Because it's a warrantless search, but it's not an unconstitutional search necessarily.
No, remember, most police officers don't have a warrant in hand when they're arresting somebody in the heat of the moment when a crime's taking place. There's this idea in the public that they get a warrant to search this. That's not the way it works in reality. So let's just look at the Supreme Court's language for the words. But remember, again, for non-lawyers, the key here is incident to arrest. Not 20 minutes before the arrest, not an hour after the arrest. So the police are allowed to search somebody who's being lawfully arrested. They can seize anything that the person has in their pockets, in their fanny pack, in their shoe. They can look in the surrounding area of what the person's around, a room, sometimes a car. That gets into a lot of areas of debate, but really the search incident to arrest is to guarantee the safety of the person. And again, remember I said officer safety, to guarantee the safety of the police. Now there's the other reason for it, which, as I think most people know, prevent an escape, provide evidence of the crime. But again, these things have to be looked at through a reasonableness search. The term reasonable is used about 600 times a day in criminal courts, and it really has to be limited to the surrounding area of the person. And that leads us into the Stairs case, which is, I'm guessing, where you're gonna go, where this search happened.
Yeah, we've only got about 40 seconds. Did the police go in a different room when they found these drugs? It seems like they were in the basement, but then they found them after. Would it have mattered if it was in the same room where he was arrested? Did they, or if they found the drugs, actually during the arrest? We actually don't have time for either of you to answer this. We've got I used up all my time on my question, but we'll go to commercial break. Then I think it's important to clarify that important factual distinction that made this case sort of stand apart. We will be right back. Welcome back to Canadian Justice, where we're discussing the law on police searches and the limits of those searches. So, Sina, in this case, RV Stairs, for specificity, when that arrest took place, did the police go into a different room of the house to find these drugs that he was charged of having possession of? Or were the drugs sort of right there to see in the room where he was arrested?
So I think that's an important factor to figure out here. And the facts are crucial as they give light to meaning. What happened in that instance was police knocked on the door, didn't get a response, and then they went in, announced that they were there, and the victim came out, but the accused, Mr. Stairs, did not. And he ran past them and went and put himself in the laundry room in the basement and remained there. What police then did was when they were going to the laundry room, they simply did a scan of the living room that was in the basement quickly for officer safety, as Ari has told us, and they go and effect the arrest. At that point, they do a scan of the laundry room itself. They don't see any other individuals there. And it's thereafter, once the arrest is effected, that they then go to a different room, being the living room in the basement, where they conduct their search. Now, the officer indicated that when he looked at the room peripherally, he wasn't able to see whether there was anyone behind the TV or the couch. And he went for a closer inspection and didn't need to move anything, and in plain sight was able to see these two items of contraband. Importantly, at trial, when he testified, he was not able to say in cross-examination whether he was where he found the methamphetamine specifically behind the couch, and more importantly, he wasn't even able to say whether he had found it before or after Mr. Stairs was already cuffed and under arrest.
So, Ari, for the purposes of the analysis, would it have mattered if they'd found the drugs before, while they were making sure the room was secure? Or if they found them after? Does that change the analysis, and should it?
So, Christine, you asked the key question. My understanding that the Supreme Court took it in their minds that they did this scan of the room. I use air quotes. The scan of the room after the man was in handcuffs. That's really important, because that's when the catch-up of officer safety comes into play. Remember, cops are going to cop and lawyers are going to lawyer. The cops' number one idea is that they're going to go home at night. But the way this case is presented to a court is that we're going to find the evidence, and once the evidence is found, we're going to say officer safety. Why? We're going to say we didn't know if somebody was in the other room. We didn't know if there were 3 Freddy Kruegers and 2 Jason the Terribles that were going to pop out. Now, this happens. Every defense lawyer who's done this for decades will tell you that this is a term that's used all the time. I've had cases where 3 cops are in somebody's apartment, and nobody's looking around, and then a sergeant comes and takes a look around and magically finds somebody. How did they justify it? Officer safety. I didn't know if somebody was hiding there. So to the precision of your question, it is very important that the person was in handcuffs at that moment. The threat is neutralized. They then do a scan. They don't say it's in plain view. But again, remember, police officers and lawyers have a disconnect. We're going to argue about all this after the fact. The police want to look around and have a sniff around and take some evidence out. That, in my view, is where the Supreme Court, again, keeps this area open by saying, look, say the magical words officer safety, and we'll tend to give you the benefit of that doubt. And many people will probably think that's a good thing.
So let's go briefly to what the Supreme Court held. Sina, the court held that the search that found these methamphetamines was reasonable. Can you explain the reasoning of the Supreme Court here, just really briefly? We'll get into the actual test itself in the next segment, but can you briefly kind of summarize what the holding was?
Indeed, it was a departure from what the Supreme Court itself had said in a prior case called McDonald years earlier. And effectively, they held that it was reasonable and the officer's conduct was reasonable because it wasn't such a high infringement on this heightened reasonable expectation of privacy that you have against search and seizure within your home.
Ari, anything you want to add there? We've got about 30 seconds.
Yeah, I think it's really important here that people understand the terms subjective and objective. The court is still going to look at whether the officer believed their life could be in danger. Somebody could pop out from behind a TV or another room. But it also has to be objectively reasonable. And that's really where the courts tend to bend over backwards at times to say, look, we're going to take the officer at their word. They didn't know who's in the house. They didn't have the architectural schematics. But when you have somebody under arrest for domestic, the woman is thought to be safe, the man's in handcuffs, there seems to be a disconnect there.
We got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the limits of police searches and the case of RV Stairs. So, Sina, let me start with you. This case, what kind of made this case unique, or what the Supreme Court was concerned with, was this test for a police search of a person's home when the search is incident to arrest. So, you presume this is different from searching a person's pockets when they're arrested. This is their actual home. What makes that such an important distinction? And what would the limits be that are established in this case? Because this case says that there can be a search in certain circumstances. You'll lay out the test of a person's home, but presumably there's a limit, right? A search of their home incident to arrest doesn't mean the police can open someone's laptop and go through their files. So what is the limit? What is the test here?
So I think first and foremost, it's important to recognize that you have a very high reasonable expectation of privacy within your home. Generally, people do, and that's what the Charter is there to protect. But what the common law does is allows police to have some powers in order to be able to execute their duties properly in the commission of the investigation. The issue here with this case, in my view, is that it extends too far in terms of the power that it allows police to search a home where you have that expectation of privacy. Previously, the law held that there had to be some sort of an imminent danger. Let's not forget that a warrantless search is presumptively unreasonable and is therefore for the prosecutors to then prove that it was reasonable. And so what this does is that it shifts that. In other words, you don't need to have this imminent danger anymore. And what the test now has become, according to the Supreme Court, is that number one, the search has to be incident to arrest. And the place that's searched has to be in the physical control of the accused who's been arrested. And if not, it has to be in close proximity to where they were arrested. And if not, they then revert back to the issue of officer safety again and again, officer safety, officer safety. So if there is some reasonable grounds to believe that there is a concern for officer or public safety, then they're able to continue the search in that fashion as well.
So, Ari, on this reasonable officer safety and police's reasonable suspicion, what would that limit look like? Is it a visual sweep of the room where the person is being arrested? Could the police go into other rooms? What would justify officer safety for police going into another room of the house, or
Sure.
Into like a back shed or something like that?
They need a warrant to go into a back shed or a garage. But let's just look at how this works in reality, because we often think as lawyers that, something we talk about here in the courts is going to change police behavior. It's not. The Supreme Court didn't even want to take this case. It was a 2-to-1 split decision at the Court of Appeal, so they're forced to take it. They didn't really change much in my view. So here's the situation. There's an obligation on officers, we all agree, to protect life and limb. They have to protect themselves and people in the surroundings. If there's a volatile situation, a bunch of people in a home yelling and screaming, that's going to give police a lot more leeway in a court's view to go looking around, to clear the house, as you'll remember TV terms from CSI, Law and Order, you got to clear the house. And that's true, by the way, I'm not being silly about it. When you have a contained situation, there's less volatility. The key to this case is it takes place in a home. Mr. Stairs or this woman are not necessarily giving license to police to do all these visual scans. They may have drugs there, they may have contraband there. It's a domestic assault call. The problem with this case, and the problem as the courts interpret this from my view, is that officer safety is invoked so that they can go for a little look around, a scan of the immediate proximity or the room just next to it. The real key here is that objectively reasonable, or is that after the fact reasoning? Why, Christine? Because they found something, so they urge a court to work backwards. The key here is you have to look forwards to say, you've got the guy under arrest, the domestic incident is contained, there's no idea or suggestion there's other people there. Does it make sense that they go snooping around this area or that area? The Supreme Court says under certain circumstances, it's okay.
So if they do find something, Sina, something evidence of a more serious crime, could they then, while doing the visual sweep for officer safety, could they then go into another room? We've only got about 20 seconds, but what would this case say about that?
I think it all will boil down to the chain of events and whether that chain is broken. If the arrest is lawful and the search incident to arrest is lawful, and then the fruits of that search produce further evidence of potentially further allegations that would come about, then yes, they are able to do that.
We got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the limits of police searches and a case called RV Stairs from the Supreme Court. Ari, let me start with you. Some people have raised concerns that expanding the potential for police to search a home during a search incident to arrest could make victims of domestic violence less likely to report the assault. Because in this case, it was a report of domestic violence. The police came in, and the abusive partner was charged with the assault, but also charged with other crimes. And there has been an argument made that some people, victims of domestic violence, may be less likely to report because they don't want their partner arrested for some other unrelated charge, like drugs, as in this case. So do you share any of those concerns?
I don't think those arguments are persuasive in practice. I think if somebody needs police assistance right away because they're being assaulted or beaten, they shouldn't think twice. And I don't think they necessarily would, because they know their partner is a drug dealer or a gun runner. If you're not calling police because you're worried that the police will see that your partner is a gun runner or drug runner, the police are probably going to know that. So I understand the concern. I think it's a very interesting talking point. I don't know that there's anything that demonstrates that point other than it being probably an appealing point for anti-social media. But at the end of the day, if you need police assistance and you know you're being assaulted, police know. Let's give police the benefit of the doubt here. This case that we're talking about today is a scan of the approximate area. They don't go through 17 bedrooms. They don't go through a Chesterfield. They don't pull the sofa bed out that guests sleep under. So I'm not prepared to go down and take that bait that this is a case that will chill potential victims of domestic violence. It also assumes most people have contraband in their house that the police don't want to see. And I don't want to think that I live in a Canada where that's such a common concern that that's going to stop somebody from calling 911.
Sina, what do you think? Do you think that this case has the potential to create a chill for reporting of domestic violence?
I think I agree with Ari for the most part, especially, but I also understand the reason why people may have that concern. And the reason is, specifically in this case, factually, the victim was very hesitant and was not compliant with police, and in fact had said that, oh, we were just messing about, and didn't say that Mr. Stairs had caused the injuries, which matters. However, I can see the allure of why people would be concerned about that. But let's not forget, expanding police powers to this extent, on the flip side, could also have an impact of being used as a sword. In other words, if you're in a domestic situation, tempers flare, and one partner would contact the police as against the other partner, knowing that there are contraband in the home, then that could also bring about potential charges that can really have some issues.
Sina, I want to put to you the case that people who support this decision have made, which is what it means for the justice system if police can see evidence of a crime, like in this case, but simply have to ignore it. Wouldn't the outcome, if the reasoning of the dissent in this case was adopted, wouldn't that be the outcome? And wouldn't that maybe undermine the public's perception of justice if evidence of a crime is in pretty clear view and the police can't do anything about it? Wouldn't that undermine a public sense of justice?
No, absolutely not. And the reason for that is that, let's not forget, practically speaking, police will never do that. Police are not going to ignore evidence in order to comply with the charter rights of an individual that they're investigating. What they would do is they would go about their conduct and then try and justify it later on in court. And that's time and time again what we see. Furthermore, it's not about the end result. It's the process that you take. And that's what the charter guarantees. Those are charter enshrined rights that guarantee us these freedoms that we have here in Canada. And if we allow police to effectively get away, even though the end result did in this instance produce contraband such as methamphetamine, it's the process that matters. You have to respect the process, because as soon as you start easing that grip, you'll start to inch further and further and further toward a police state, which is not good for anyone.
Ari, 10 seconds. Any last thoughts?
I agree with Sina. Quite frankly, I think his answer was spot on. And at the end of the day, police are not going to turn a blind eye when something's in plain view. So nobody needs to worry that the police are going to see a gun and go, uh-oh, the stairs case means we have to leave the house and go back up the stairs.
All right. Thank you both so much for coming on today.
Thank you.
It's been a pleasure.
We've heard today about a recent Supreme Court decision that sets out the test for how much of a person's home can be searched by police when they're arrested. The court's trying to strike the right balance between limiting warrantless searches and ensuring police and public safety. Did they get the balance right? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.